under the aegis of the Honorable High Court of Sikkim in collaboration with the Commonwealth Legal Education Association. We are deeply honored by the presence of the Honorable Judges of the Supreme Court of India, whose wisdom and commitment continue to uphold the rule of law and inspire confidence in the justice system. We also extend a very warm welcome to the Honorable Chief Justices and the Honorable Judges of the High Courts from across the country, whose tireless service forms the backbone of our justice delivery system. We are privileged to have with us our esteemed host, Honorable Mr. Justice Bhaskar Raj Pradhan, Judge, High Court of Sikkim, and Chairperson, Judge in Charge of the Sikkim Judicial Academy. It is our privilege to extend our gracious welcome to the Learned Attorney General of India and the Learned Advocate General of Sikkim. A special welcome to the esteemed representatives of the Commonwealth Legal Education, directors of state judicial academies, eminent academicians, distinguished members of the bar, and senior law officers present amongst us today. We are pleased to welcome the research fellows from the National Judicial Academy, Bhopal, learned judicial officers of the state, and advocates whose dedication to legal scholarship and practice strengthen our institution. Last but not the least, a warm welcome to all other participants and stakeholders, including students present here today. Your presence adds immense value to this conference. As we gather here today, we are reminded that just as Sikkim harmonizes tradition with modernity, our judicial system must also evolve, embracing technology while preserving the core values of justice. The administration of justice is undergoing a significant transformation, driven by rapid technological advancement and the growing complexity of legal system in a globalized world. Courts are increasingly adopting virtual hearings, digital records, and data-driven processes, while judicial academies are rethinking traditional training methods to meet these evolving demands. In this context, the need for meaningful dialogue and collaboration among Commonwealth nations becomes essential. Coming to the aims and objective of the conference, this conference seeks to provide a collaborative framework, a platform for Commonwealth judicial educators to exchange best practices, explore innovative e-learning and virtual training methodologies, and share experiences in integrating technology into judicial curricula. The conference also aims to promote cross-border cooperation in developing digital competency, standards for judges, strengthen institutional networks, address ethical consideration in the use of AI and digital tools, and encourage collaborative research on the future of judicial education. The conference is structured around 4 thematic sessions spread over 2 days, each addressing a critical dimension of the interface between technology and judicial education. The first day, which is today, will focus on how technology is reshaping both court functioning and judicial training, with emphasis on operational and pedagogical implication of technological integration. The second day will expand the discourse to a broader global context, addressing the impact of transnational legal developments and the need for collaborative frameworks across Commonwealth jurisdiction. With this, we now proceed to session 1 on virtual court management, challenges and best practices. Please allow me to introduce the distinguished dignitaries for the session. May I humbly request Director, Sikkim Judicial Academy, to kindly offer khada as a mark of our respect and appreciation. It is my immense pleasure to acknowledge the esteemed presence of Honorable Mr. Justice Prasant Kumar Mishra, Judge, Supreme Court of India, as the chair of this session. It is also my honor to introduce the panelists for the session. Our esteemed panelist comprises of Honorable Mr. Justice Hamarsan Singh, thank you, Judge, High Court of Meghalaya. Honorable Dr. Justice Sanjeev Kumar Panigrahi, Judge, High Court of Orissa. Honorable Mrs. Justice Preeta A. Krishnama, Judge, High Court of Kerala. Mr. Basava Prabhu S. Patil, Learned Advocate General of Sikkim. We are also honored to have our moderators for this session, Honorable Justice Gopinath P., Judge, High Court of Kerala, and Professor Dr. Richa Chowdhury, Dean, Sri Guru Gobind Singh Tri-Sanitary University. May I also inform the august gathering that amongst us, we have Mr. Legdan Basi, Advocate, High Court of Sikkim, as the discussant for this session. Thank you, ma'am. For Legdan Basi. With these words, I humbly invite the Honorable Chairperson to formally begin the session.
My esteemed brother, Justice Ujjwal Bhuiyan, Judge Supreme Court, Brother Justice Hamarsan Singh, thank you. We always call him thank you. Judge Meghalaya High Court, Dr. Sanjeev Kumar Panigrahi, Judge Orissa High Court, Mr. Justice Gopinath P, Judge Kerala High Court, and the latest edition baby judge, Justice Pritha, Judge Keralam High Court. High Court is still Kerala. Still Kerala. Yes. Mr. Basav Prabhu Patil, the learned Advocate General of Sikkim. We see him regularly in Supreme Court. And Mr. Professor Richa of SGT University, Gurugram. Mr. Legdan Basi, Advocate, Sikkim High Court. And the galaxy of judges from different high courts present over here. And dear participants, a warm welcome to you, all of you, in this conference and in this particular session where we will be dwelling on the virtual court management challenges and best practices. And this particular day will be remembered and it will be etched in history as today Sikkim has become the first state judiciary in the country to go paperless. Really, it's a great privilege to be part of this conclave and conference, and I thank the High Court of Sikkim for facilitating this conversation, which I believe our judiciary needs to be having urgently and collectively and regularly. We meet today under the broader umbrella of judicial education in the digital age. Under that umbrella, our session addresses something more specific, that is virtual court management. It is perhaps opposite to begin by quoting the leading common law authority on natural justice, 1924 decision of the King's Bench in the case of Sussex Justices ex parte McCarthy, where Chief Justice Haworth had famously held that justice should not only be done, but should manifestly and undoubtedly be seen to be done. In this phrase, the word seen to be done makes virtual courts both promising and challenging. Back then, it was inconceivable that the bar, the bench, the witnesses, and the public at large might all be in different rooms, different cities, even different countries, and yet they are part of the same proceedings at one singular point of time. However, our obligation as the judiciary has changed. We have a constitutional and legal responsibility and not just a technical one to ensure that justice is both done and is seen to be done. Our session today aims to identify common challenges across the Commonwealth and to explore practical solutions and models. I will touch upon a range of sub-themes and try to offer insights from the Indian experience. When I say I, it is the whole panel, particularly that of the different courts in the country, because we are now discussing the best practices in the virtual court management, the challenges lying ahead of us, challenges which would include the use, how to put the maximum use of virtual court and how to eliminate its misuse also in due course, which we have been seeing every now and then. Coming to the transition from physical to hybrid and fully virtual courts across the country and Commonwealth, the story is broadly similar. Even before the COVID-19 pandemic, most jurisdictions had experimented with some degree of virtual court proceedings, and the pandemic accelerated that shift. In India, for instance, as far back as 2003, the Supreme Court, in the matter of Praful Desai, had extensively examined and approved the use of video conferencing to record evidence in appropriate cases. Large-scale efforts were parallelly underway through the National E-Governance Plan. In 2015, the Department of Justice had reported that video conferencing facilities were available in 500 court complexes and their corresponding jails, and the number is counting. We are now in 2026. When the COVID-19 pandemic then was catalyzed this expansion largely by leaving us no other choice. By March 2020, the Supreme Court was fully functioning virtually. Further, it was the subsequent institutionalization that secured us lasting gains. The Supreme Court moved online. The very next month in April, the then Chief Justice, Dr. D.Y. Chandrachud, had emphasized that all the work being done was with an eye to retain what had been achieved even after the pandemic. And we can see these ourselves. When the court reopened in March 21, a hybrid model was put in place, which continues to function robustly. 5 years on, official figures indicate that across the country, nearly 4 crore virtual hearings have been conducted till date. This pace is nothing short of striking, amazing, and breathtaking. Here we can also examine the trajectory in other Commonwealth nations. For example, in Singapore, around 90% of criminal and civil non-trial matters and over 60% civil rights cases, civil trials, were heard entirely remotely in 2021. In UK, court buildings had to shut by March 2020 and hearings shifted online. Platforms such as the cloud video platforms were put into use and continued to be used extensively in both Crown courts and magistrates' courts. As judges, many of us were unfamiliar with or even skeptical about technologies like these, such as Zoom or Cisco WebEx. Yet, during and after COVID-19, our adaptation was both rapid and durable. Today, all over the world, hybrid courts have become a settled feature of the legal landscape, owing in large part of this judicial education of judges and judicial officers. At the same time, I will add that infrastructure remains decisive. Judicial willingness alone cannot substitute for it. In fact, now judges are also asked to assess, balance, and make a call about the appropriateness of virtual courts. Just to offer some examples from India, there have been pleas before the Madras High Court about the Tamil Nadu Waqf Tribunal, or before the Delhi High Court about the Central Information Commission, to introduce virtual hearings. The high courts in these cases correctly appreciated that there was simply not adequate infrastructure in these forums to give effect to such a direction, even it was passed. Therefore, there has to be sustained and meaningful investment in equipping courts with the infrastructural foundation. In Supreme Court, we come across almost every fortnight when we pass orders mostly in transfer petitions, that parties would be allowed to join virtually, either of the spouse, whenever they say that please allow the transfer petition, but allow me to appear virtually, quick comes the objection that there is no virtual hearing facility in that particular district, maybe somewhere in some other remote corner of the country. So that assumes significance because we want to assist the litigants, the parties, to become virtual, to go for a virtual appearance in the court proceedings unless their physical appearance is mandatorily required as part of the proceedings. But sometimes it becomes a bottleneck. There are competing views. Many contend that virtual hearings expand and enhance access to justice. However, others feel it dilutes the quality of justice itself. As mentioned above, historically, we never even had to question what it would mean for participants not to be physically present in a courtroom. So we have to re-examine what it means to be properly represented in proceedings. The most difficult question is about adherence to the principles of natural justice in course of hearing, or the procedural fairness of having virtual hearing. Again, we observe that Commonwealth jurisdictions have grappled with this in their own different ways. Here we can see a decision of the English Court of Appeal delivered fairly early in the pandemic on 22nd April 2020. The court therein had set out a list of factors to guide judges in deciding whether a virtual hearing is appropriate in a given case. The factors which were delineated, the importance and nature of the matter, whether the relief sought is interim or final, the urgency of the case and the consequences of delay, whether the parties are represented, the ability of any unrepresented party to effectively participate in a remote setting, the nature of the evidence, the scope and scale of the hearing, the technology available, the experience and competence of all participants, including the court, and whether any viable alternative exists to facilitate a physical hearing. Maybe these are the factors which then in April 2020 came to the mind of the judges. And after 6 years, now we may be required to change these factors because we have gone ahead and ahead to the extent that we have reached to a point of no return. Virtual hearing has become a necessity nowadays. This framework captures in substance the considerations we routinely have to weigh. Many a time there are situations where practical constraints such as last-minute listings make virtual hearings convenient and expeditious for all those involved. In matrimonial disputes, virtual hearings often give us the benefit of hearing directly from the affected parties. In this way, they even enhance rather than take away from the human texture of the case. Conversely, in matters with broader public impact, courts and the parties themselves prefer and insist on physical hearings where they can engage more fully and the process retains its institutional gravitas, so to say. I remember immediately after onset of monsoon, I was then the chairman of SLSA, executive chairman of SLSA in Chhattisgarh, and virtual hearings had begun. And there we felt the necessity of encouraging the parties to compromise. Some hearings were taking place, and it suddenly occurred to me that if hearing can take place, why not compromises? Why not Lok Adalats can be organized? And I can say on 11th July 2020, Chhattisgarh was the first to stage state-level e-Lok Adalat, and nearly 2,300 cases, maybe more than that, I do not remember the exact figure, were disposed of. And I was particularly happy on that day. Then we saw, and it was widely reported that time also, we saw farmers having a mobile in their hand, working in their agricultural field. July, with onset of monsoon in Chhattisgarh, it is totally wet. Farmers were there. They were knee deep in their agricultural field, full of water. And they said that, yes, I am willing to compromise. Those were the scenes early 2020. In one matter, a litigant was not in Chhattisgarh. He was traveling somewhere near Patna or maybe some other location in Bihar. And with mobile in his hand, inside his car, he said, yes, I am endorsing the compromise which I have entered. So this is the strength. This is the impact of virtual hearings. Virtual hearing, though of course we sometimes hesitate and we avoid also to do final hearing matters, like the factors which have been noted by the English court, then when the matter is very important, it will take much time to hear, and the points are also very intricate, or it involves some constitutional, then probably sometimes you tend to think that physical hearing would be a better option. Because after all, when you are face to face, and even lawyers also feel that when we see the judge, his reaction, sometimes they feel that it is not only the demeanor of the witness or the other parties, the demeanor of the judges are also important in course of hearing. So sometimes lawyers also feel comfortable in physical hearing when the matters are required to be heard at length. There are pros and cons, merits, demerits of this virtual hearing, but it has to come to stay. We need to live with it, and we need to live with it in a more perfectionist way every passing day. And there will be a time when most of the matters will be argued virtually. And we, as a court, we must encourage that. Now we will hear from our brother judges and other panelists about the best practices prevailing over there. Mr. Panigrahi is from Orissa. He will tell us what is happening in Orissa, how far they have gone. Then other judges, thank you, will tell about his court. Mr. Gopinath, Madam is new, but at least he must have come prepared. Anyway, thank you so much. And we hope that this two-day conference would be a hugely successful conference. Thank you, Sikkim High Court and Sikkim, for this wonderful hospitality. And we look forward for very absorbing conference today and tomorrow. Thank you so much.
Thank you, Justice Prashant Kumar Mishra, for that enlightening address on the subject matter of discussion. So how we have planned it, I think we have already discussed this with the panelists. With the permission from the chair, myself and my co-moderator, Richa, we have planned that we will put questions generally. We want this to be an open discussion. The Attorney General is here, and many other learned judges, Justice Bhuyan is here, many other judges. So again, with permission from the chair, if there is anything that anyone would like to add to the discussion, we would welcome you to add to it. So we will start by asking the first question to the panelists. Any one of you can take it up, and we will go forward in that manner. So this is the first question: transition from physical to hybrid virtual courts. That's the theme. What have been the most significant structural and cultural barrier courts faced when shifting from physical to hybrid court models, and how were they overcome? The first question to the panelists.
Actually, good afternoon, everybody. Justice Prashant Kumar Mishra, Honorable Judge, Supreme Court of India, Justice Ujjwal Bhuya, Judge, Supreme Court of India, and all the panelists and my brother and sister judges and all the judicial officers present here, and the learned Attorney General and Advocate General of Sikkim. So here, the first thing is that suddenly there is a change from the wooden bench to webcam or maybe 13, 17-inch screen. So there is definitely a cultural shock to the litigant as well as the judicial system, because it was when the pandemic started, so there was no option but to adopt such method. So this transition from wooden bench to a webcam bench, that has actually a lot of psychological and cultural barriers initially, but gradually we overcome the barrier, because there was no option at the time. COVID was there. So we can thank COVID for making our digital transformation so much rapid, though it was going on, but there was a rapid transformation. And the psychological barrier, in every change you see there is a psychological barrier. The same thing happened in this case also. People started, especially the lawyers, started objecting to these. Say, how is this possible that many people, they're not friendly with the digital device. They're not friendly with the court culture in the virtual setting. So all these things actually, that took a huge toll. And gradually, of course, with the hand-holding support by every court system, especially in Orissa, let me tell you, we had a hand-holding training exercise everywhere, in every district level we had that. And we started encouraging the lawyers and their lawyers' clerks. The clerks were trained. Virtually we trained the clerks in every district. And those, because they are the the stakeholders in the system. And if you just touch them, and of course the lawyers, especially the old lawyers, so who are slightly averse to the use of technology. So these things really help us in just getting the support from the system, for the system. And this is how we have just changed the culture of that, there was a change in mindset. Yes.
Good afternoon, everyone. I'm Justice Thank you from High Court of Meghalaya, like Honorable Lord Chief said. Thank you. Anyway, like from what my brother said, now I feel that like in this session that we're having, is that it's a capacity build. You know, the people who are using this technology. The others, I think the other conference is with regard to the technology per se. Out here is like how do, we make litigants, especially our officers, comfortable with technology, and how do you use it? And so what we can see in our own experience is that when we started, we had a lot of, we lacked proper digital infrastructure. So there was no stable internet. I'm talking from the experience of our state. And so we didn't have proper video conferencing tools. Sometimes the machines are already there with the digital platform, with the VC platform was given, they weren't compatible. So these were the things that brother said, that when the COVID came, so we had a lot of issues, and especially coming to the judicial officers. So how are you going to tackle with that? So I feel that to a certain extent we've overcome that. And as we're all sitting here today, I think we're looking at a very bright future, but only how to balance the use of this hybrid, this system that we're having now. So I think with the e-courts project and a lot of investments in technology, standardizing everything across the country, we're looking towards a proper kind of a framework which will, sort of govern the entire system, judicial system. Maybe we'll have a policy body, or maybe we had an executive body, a legislative body that will control. We have to have from training aspect to the use, and also how it's not on public interest, how the public will be most benefited. Yes,
Now, if I may
Yes.
add to what the, if I may. Now, the panelists here were discussing about the phase which they saw as judges, but now, since I'm only 4 days old, I can say what happened or what was the impact that had on lawyers, especially in Kerala High Court. In fact, that was a period where the Kerala High Court was working on under the leadership of Honorable Justice Mushtaq sir and Vinod Chandran sir. They were running the system of case management system. And then suddenly the COVID came. So we say that there was resistance from bar at that point of time. But that was basically an issue with the internalization. Because all on a sudden, we had to move to a digital system. But at that point of time, what we were instructed was, you draft the original or writ petitions, like what we used to do, get it scanned and then send it up. So that was an easy mode for a beginner. But then, as days progressed, what happened was, we could see a divide between the seniors and juniors, because the younger generation were very familiar with the digital technology and they could easily catch up. Whereas the seniors, all of whom may not be on the same economic level, they faced a lot of difficulties because either they had to give up the practice or engage persons to help them with to cope up with the situation. And I've seen many senior lawyers who have stopped practice. And second thing was, all on a sudden, the advocate clerks became not a necessity to a lawyer office. And that phase also created a lot of difficulties in the process of digitalization. Now, another aspect was, along with the technological advancement, or when we switched over to the technical side of virtual courts, there was a divide between the urban area and the rural area. Because rural areas at that time, what happened was they could not step up with the technology. So what happened was cases got adjourned because nobody could appear before the courts. And in high courts, especially, we never, as personally for me, we never used to feel very comfortable arguing before the courts because we feel that our presence there would make a difference and they wouldn't let us there. So these type of issues we faced all throughout that initial phase of COVID. Then along with that, we had to upgrade our office because initially the process said you need a scanner, you need to upgrade it. Then came a phase when they said you need to have, initially this was from ledger to A4 size paper. So that was the infrastructure everybody was getting. Then they said, no, we will go with the entire thing, we will go for scanning. Then this upgradation again happened. And so this transition was not over a period, but we had to go at a quicker pace so that everybody would cope up with the system. Now, that is why we said there was a resistance because economic factors were also criteria which detain them from moving forward. Now, as far as the lawyers are concerned, as I already said, we never felt comfortable arguing in virtual courts because at that time we had this problem of mostly cases would not be heard, only interim orders were being passed to get, for about 1 or 2 years the matters got prolonged unnecessarily. So this was, and the clients also had this problem. So over the years what happened was we ourselves tried to educate ourselves saying that this is the order of the day, we have to move with it, and then these barriers became the Advocates Association started supporting the lawyers and we could cope up with that pace. Now, as far as the hybrid court infrastructure, the courts also started upgrading the infrastructure and matters started going smoothly only over a phase of 2 to 3 years. So that is one issue that we could see. It's not a cultural barrier. It was mostly an economic factors that created so much of hurdles in the institutionalization of the hybrid courts.
Distinguished Chair, co-panelists, distinguished audience, learned Attorney General. It's a privilege to be part of this session, Virtual Court Management and Challenges and Best Practices. From the standpoint of the bar and the state, I would put the issue in one sentence. The future is not fully physical and it's not blindly virtual. It is intelligently hybrid. Technology may create a virtual courtroom, but the management is what makes it a court. The challenges or the barriers in shifting from physical to hybrid, which I have noticed, the biggest barrier was not technology, it was habit. Courts, lawyers, litigants are deeply attached to physical court culture. They file, the courtroom, the passovers, they mention the physical presence of the counsel. The solution is not to force a sudden shift, but to build confidence through phased adoption. Begin with categories that are naturally suitable for virtual hearing, procedural matters, short applications, directions, bail extensions, case management hearing, and appellate matters where the record is already crystallized. The Supreme Court 2020 video conferencing order itself permitted high courts to adopt modalities suited to local conditions and recognize the VC facilities must be made available to litigants without access. As a practicing lawyer, I have noticed that there are several advantages compared to a few disadvantages. In COVID, it was phenomenal. From a challenge, it became an architecture for the future. But I found certain shortcomings in certain models that have been adopted by the High Court and Supreme Court. I faced a few critical challenges in Supreme Court. One of them was unmuting is not with the lawyer. I understand it disturbs the proceedings, but I found when I was on caveat appearing for a party, I was not unmuted and the matter went by. Sometimes we noticed the respondent spoke and the appellants were not unmuted. So it was a difficult phase, but these are smaller issues which will be ironed out. But again, in terms of technology, different courts are adopting different technologies. Microsoft platform is being adopted. Some are adopting vCounsel. I feel a uniform practice across the country will make it easier for all the lawyers to understand, appreciate and adapt themselves. These are my opening remarks. Thank you.
Before we move on to the second question, ma'am, with your permission, just one thing. I've been speaking about this, so I thought I should mention this because it's connected with the first question. Junior lawyers, young entrants at the bar, I have a strong feeling, this is a personal feeling of mine, I don't know if anybody else will share it with me. I feel that the use of language, the fact that they enter the courtroom through virtual platforms, don't see the seniors arguing, don't learn the method of, addressing the court. Some people now start using yeah instead of yes. And how do you think that, as far as the youngsters are concerned, is this a cause of concern? Because they have not been able to see the seniors arguing and learning from them.
I think like any other guidelines, we can issue guidelines to uniformly throughout the country. I mean, what kind of the code the menus should be, what the language should be used. In that way, we can have something. Gradually, we have to adapt it because this is hybrid is bound to stay in the country. So when you are living in that era, so these smaller things can be ironed out. I don't think there will be any problem.
What the question or the problem highlighted by Brother Gopinath is of great importance, and it has a significance in our whole judicial system and the court proceeding, how it goes. We are already facing problem of behavior from either side, the bar as well as the bench. So then in the era of this virtual hearing, he is quite right in raising this topic that if juniors don't enter the courtrooms at all in their initial phases, in their initial days of practice, and they don't learn the etiquettes, the mannerism, the decorum, or the whole ambience of the court, then probably they may not, while addressing or presenting their case, they may not be so effective. Effective in the sense that when you argue a matter in a very head-on kind of situation with the judge, with the court, or with the other side, then the loser is not the counsel, but the loser is the litigant. So keeping in view the all the stakeholders, their benefits, he has a point, and we must think of a solution to this problem as to in the initial days when a young lawyer joins the bar, joins the practice, what should be the practice or the teachings which should encourage him to learn the etiquettes of virtual hearing, etiquettes of courtroom hearing and etiquettes of virtual hearing should be taught initially to all the lawyers. That is what.
Just to add to the Honorable Chair, the answer would be we must preserve courtroom dignity. A virtual hearing is not a webinar with a course title. It's a court. The same discipline, courtesy, seriousness must travel from courtroom to the screen. Australian Federal Circuit and Family Court, for instance, expressly reminds participants that conduct, dress, address to the judge, muting, early login, and prohibition on recording apply equally to electronic hearing. So these are the best practices which we'll have to cultivate and educate people. Nothing is easy. It's a transition. So it will take some time, and people should be educated about best practices.
Thank you so much, sir and ma'am, for enlightening us. Our second question is that how do you ensure that hybrid model does not become a two-tier system, one where in-person participation have an inherent advantage over the virtual one? Even sir has said that advocates are more inclined toward coming physical rather than going toward the hybrid model.
Yes, if I may answer that. I mean, a two-tier model will have its disadvantages. Because you see that as a judge, if a lawyer is physically present, he makes a far greater impact. So how do we ensure that they have a level playing field when it comes to virtual? So that is what even myself also have not been able to come to, to what can be done. Because usually, like the learned advocate general said that they can't unmute themselves also. And so sometimes there's a small technical fault, or maybe they can't make themselves heard properly. Sometimes due to technical issues or the kind of equipment they use. But I feel a person who is physically present is more likely the scales will weigh in favor of the person who is physically present. I don't know what my other panelists feel, but I feel that way.
I've seen in the cases where some people are appearing, some lawyers appearing in the virtual settings, because of technological disruption, something it irritates the judges. And on that irritation, he loses the case also. So that has to be, there should be level playing field, of course. I don't find any solution. It in fact irritates many. That everybody is not a very stable, cool judge. No? There are some irritating judges, sorry, dismiss. So that goes. So the fate of the client is gone. So that is very important.
And adding to it, the disadvantage of a virtual hearing is that if the judge is not inclined and judge tells his court master to switch off immediately, and he doesn't have the second chance to convince the judge by making a request, because sometimes what happens, a young lawyer may forget his best point to be argued at the beginning. And he becomes late, right? And in virtual hearing, 30 seconds late at the end of the hearing is end of the game.
Yes.
So that is one of the major disadvantage of a virtual hearing, and I have also done it. Sir.
There is one more thing. In many systems, what happens is like you can see the judge, you can see the other side, but you may not be able to hear the other side arguing properly. So you may not be able to respond to that at that pace. So that also creates a lot of problems.
2 quick points. The danger is real. The person physically present may appear more persuasive
You are saying danger is not virtual.
The practical model would be every hybrid hearing should have a fair hearing checklist. Visibility, audibility, access to documents, opportunity to respond, and confirmation before conclusion that all sides were heard.
So we move on to the next theme and the next question, which is digital case management systems promise efficiency, but many courts report a paradox, that is more data yet slower resolution. What explains this and what models have worked?
This digital court management has a a lot of inherent challenges, especially when finding the pages. Though you have all these, when you have the scanning and everything, sometimes because of because every high court has its own, technology and the model they are following. Like Kerala, you have a seamless thing. You find the page easier than with some other high courts. We are using the Wacom. They are getting the pages become difficult. So these are some of the challenges that need to be ironed out. So unfortunately, every high court has its own model, and they don't want to share with the other high courts. So there should be some, with the help of the E-committee, there should be some, easier solution to this problem. This is one. Secondly, when we are basically using this technology, the, the, the paging, the opening the pages and making notes there. These are some of the challenges that is still very, I mean, it's not like in the real sense, what do we make notes in our file. That becomes a really difficult thing. So that is one of the major challenge.
If I may say something, is that these digital systems create a large volume of data. That is one thing. So courts now, they record every filing, every order, every step. It increases transparency, no doubt, but it's added to the workload of the court staff, to the judges. So what happens is spend more time managing the data that they are collating and collecting than deciding cases. And sometimes also these old processes are simply digitized. So they put a digital form. So the same complex procedures continue. Technology alone can't solve this. Then sometimes, like we have in most cases, because we're dependent on the NIC, then we have a post-system design. So that also, another software are user-friendly, then it creates a lot of frustrations also. Especially because the court staff, see, they now, before maybe the orders are passed, or now they have to upload them, they have to wait, sometimes they're there till 11 or 12 o'clock at night, just to see the orders are uploaded, because we have a lot of compliances nowadays, especially with this transformation into this digital world. And so now that means we have to train judges, lawyers, court staff again and again, so we don't understand fully how the whole thing, we can manage it more efficiently. So if data is collected but not properly used, then there's no point of collecting that data. That's my personal feeling. Yes. Yes.
Unified indexing system and unified e-filing system throughout the country. That should be same in every high court. That will be, I think, that will make things easier, because every high court has its own things. So if we have a unified system of opening the PDF file, making notes, everything same in all high courts, and there should be some, our indigenous system will work. Every time we are dependent on some other system, so that will never help. So because we see in Delhi High Court, they have a system of making notes, which in our Wakam it doesn't work. So we just discuss with them. They say, okay, this is how we do, but our system doesn't. Actually, that is not compatible. So there should be some technology that is more compatible. So that will really help. And second, this e-filing protocol should be same in all high courts. That is again a big problem. If you have a standardized protocol of e-filing, so then the things will go in a systematic way. Yeah, that could be user friendly. So both the court and remember one thing, we are using paperless court. What we are calling paperless, actually not paperless, it is less paper court. Because other side using paper. So the lawyers are using paper. Only this side we are calling it paperless. And we are also signing the document.
Again, a sub-question. This is only for the judges. Not for the lawyers. Again, staring at a screen from 10:15 in the morning till 4:30 in the evening. In the first system, Preeta was explaining how we managed during COVID. We had scanned documents. I was sitting during vacation during that time. End of the day, you're finished because you had nothing. You had just scanned repetitions. And you were staring at the screen from morning till evening. And during vacations, you had 200, 250 matters on the board. So this is again something.
There will be another big issue of screen fatigue. So everybody is sitting for hours together before the screen. So that is also another challenge. So if you start sitting before the screen, when is the chance for getting sufficiently leisure time to dictate orders and all these things. So this is also a very important issue. So we focus more on the system management rather than the other part. This core system sometimes get lost.
Thank you so much, sir. Since we are running short of time, so our next question would be with Mrs. Justice Preeta. So how should court handle cases filed under the old physical system when transitioning to the digital case management without losing that continuity?
because as far as I feel because we have the old file system. Now what we can do is we get all those scanned, then integrate it with the new filings and then use it. Otherwise, I don't see, or the court should continue with the paper system till the old files are disposed of. That are the two options that we have.
And how will you handle part physical, part digital records?
No, because I think in our courts, we have the paper files as well being sent to courts. So as far as
The entire record, whichever is in physical form, that has to be digitized and scanned and made. The old files also has to be digitized and simultaneously this has to
I
be
think
done.
almost all the courts are going through that process of digitizing the old files.
Record. It is happening everywhere.
What we see in Odisha, we have actually taken the digitization move to in district courts. So in district courts, what we do in every district court, we encourage the e-filing. At the same time, we have a hub. Every 2-3 districts, there is even bigger district than is a one. In there itself, there will be a hub. Otherwise, there will be a hub. For smaller districts, we have a hub. We have 30 districts. We have made 4 or 5 hubs. And for bigger districts, no hub. So in that way, the digitization, the activities is going on. At the same time, the e-filing is going on. Partly paper code is also going on. So in that way, it has to be simultaneous. Otherwise, one thing will happen after all the digitization activity, then only will start and that time will never come.
That's
So
why
that's the thing.
I think the old files are being sent up. The paper files are also being sent up for disposal. That,
So we move to the next theme. I think this the principle of audi alteram partem requires that every party be truly heard. How do virtual hearings risk undermining this, and what safeguards can courts build in? I think the speech of Justice Mr. You touched upon this already. So some additional points, if any. His Lordship has already covered this in detail.
Yes, yes.
yesterday, while I was traveling from Hyderabad, I had met former acting Chief Justice Naveen Roy. So he was telling about the COVID time, how he managed the system. So he said, since clients could not access the digital system, the courts went to them by, they had summoned school buses during the COVID period, and these school buses were equipped with video conferencing system, and those went to all the lesser rural areas so that the clients could access the courts and the lawyers could also access. That is one way how we can, the alternate systems should be developed.
It's a point of fairness. Audi alteram partem
Point.
is a point of fairness. According to me, the principle of audi alteram partem cannot become audio alteram partem in the literal sense, where a litigant is technically present but not truly heard. Connectivity failure, poor audio, language barrier, lack of digital skill, or an unseen litigant sitting in a remote village must not become silent form of exclusion. Therefore, every virtual court system must build in connections checks, help desk, digital access points, simple adjournment protocols for genuine technical failure and legal support.
What Mr. Patil said is about the court side. When there is some failure on the other side, on the side of the lawyer, and he is not aware, like what was said, that if there is a lag, suppose he is arguing one important point and there is lag of 30 seconds, 40 seconds, the judge has not heard it. He was not audible during that 30, 40 seconds. And then he again continues. He is under impression that he has been heard, when actually the judge has not taken his point. And it happens quite often that we miss what is argued by the lawyer, and that maybe is one of his best point. what I think is that in the entire discussion, what occurs to my mind is that there should be an SOP put in place, and apart from that SOP, there are guidelines, there are do's and don'ts, which should be made known to every participant. For litigants who have logged in, there will be different kind of SOPs and do's and don'ts. Like one came across 2-3 days back, one of the participant did something and in Delhi High Court. And then about the lawyers, if the lawyers are aware, these do's and don'ts for the lawyers may cover the courtroom etiquettes, the courtroom decorum, how he would maintain, and every time a lawyer logs in, opens the page, then these do's and don'ts must appear on the screen to begin with. That these are the do's and don'ts, and he must read and he must follow before proceeding to address the court. That should necessarily be done in times to come, and that would probably alleviate some kind of our apprehension about the misuse of, ill use of this virtual hearing.
My concluding remark, I think we are out of time.
Yes.
Virtual court should not become a weaker version of physical court. It must become a better managed court.
Yes.
Thank you so much, sir. Moving toward the theme 4, that is cybersecurity, data protection and privacy concern, which is again a very important topic. So the question for this is that how should court balance the principle of open justice, that proceedings be public, with privacy and data protection obligations in a digital environment? Any of the panelists could answer.
Recently, actually, one incident happened. Suddenly, in High Court of Karnataka, Odisha, and I think Assam, or 2-3 other high courts, some ugly scenes were suddenly cropped in for 1 minute or so. And this was, you can't show that. So somebody from Bangladesh or somewhere sees some, this kind of cyber attack comes. So unless you have a system of robust the cyber security protocol, so these things are also going to happen, and the court, the virtual court system will definitely suffer a setback. And more importantly, even we are using the net from either BSNL, MTNL, or in Odisha we have two, BSNL and Railtel also we are using, so to avoid any kind of disruption in this. But one thing which I used to request the E-committee members also, please do request the government to have a separate tel like Nyaya tel or Justice tel, whatever you call it, so which will be only utilized for the purpose of the judiciary only. So there will be more data, there will be more security. So the chance of this, the cyber security will be better. So therefore, those who are in the E-committee, please do put in a word before the government that we should have a, because we have a huge network of the judiciary throughout the country. If we have a separate network, that will definitely ensure better data protection and better, cyber, the attack and all these things. Of course, other things we have to have a mechanism, we have to have a standard protocol for that. That is non-negotiable. Thank you.
If I just may add here, I think that is something we have to live with. Because hacking happens everywhere. We were just talking to, a person in charge of bank security in the state bank, in the main hub. They said every day there are around 1,000 attempts to hack the mainframe system. So that it's a living reality we have to live with. That means we have to have stronger encryption tools, or what we don't know. I'm not a technical person, but the people in the technical side will have to, it's like putting that added armor again, because we're handling sensitive data, handling sensitive issues, and so we must protect the vulnerable data. So So these are the things. So login passwords or passwords, these systems won't work. And as they also always one step ahead. So that's the thing, we are the living reality or living danger we're living with. So that, what my brother says is correct. Also, we have to have some kind of maybe like an iron dome kind of system, for judicial, the virtual courts, regular security audits. Otherwise, it's something which we have to live with. That's what I feel.
Thank you so much, sir. Moving toward the next theme, that is access to justice and digital divide issue. So my question is that digital court risk becoming elite courts, that is accessible only to those with devices, connectivity and digital literacy. What affirmative steps must judiciary take to prevent this? Any of the panelists could answer.
The digital divide is of course a very big issue, because there is in India we have all the places in the country are not equally accessible to the net connectivity. Especially in the rural area, they are facing big challenges. And what we have done in Odisha, there was an insistent demand for separate benches in different parts of Odisha. So what at that time Justice Muralidhar, when he was the Chief Justice, what he did, he set up a virtual court unit in every district, 30 districts, 30 virtual center. So there, the lawyers from the district court, they used to file the cases, they used to argue from there, especially the bail matter, the 482 matter, like this. So these also helps. A lot of lawyers, they didn't have to come to High Court for that. So that is a great help. So whenever there is this kind of problem is there, the High Court, the E-Committee, they should have a more such, now E-Sabha Kendra is there, so they can have more such kind of the center in every district level, so that will enrich the people, that they can embrace the system. And the digital divide, there is of course big challenge, so that can be addressed, I think.
In my opinion, to overcome this digital divide or access to justice, what Ms. Richa means is that facilities are available to some and it is not available to others. To overcome that, we may think of having a video conferencing center with multiple login facilities in different district and taluk courts. Like in bar room, there is a library, a part of the library or one digital room itself may be converted into a digital courtroom for those lawyers who don't have their own system. They may come to court at 10, 10:30, 11, whatever time, and they just enter the video conferencing room of the district or Janpad or Taluk court, and then they log in and switch address either the district court or the high court or elsewhere, wherever they want to log in. So this could be one, this facility can be created to remove this digital divide between the poor lawyers, poor litigants, and those have or have nots. And use this digital divide or any kind of divide, when a new technology or a new facility is created, there is always in the initial phase, there will be a divide everywhere. This divide is removed slowly by lapse of time, when everybody will have this facility on touch of the button.
A digital court should not ask the poor litigant to become digitally rich first. I think legal aid institutions should become digital bridge or digital court facilitators. I think that would perhaps soften the divide.
The district courts, we have not less than 23 lakhs cases we have heard and disposed of through that district court centers. Every district has centers. So we can also, I mean, further you can go to the taluk level also. So that model can be adopted everywhere. So that will help in solving the problem of digital divide.
So, moving forward, the last question of the day. How should judges handle disruptive or disrespectful behavior during virtual proceedings, particularly when the offenders is in a different jurisdiction or even from different country?
This is about the lawyers or the litigants?
So both.
For the, no, errant court or errant lawyer? You see, of course, the court procedure, how the court will conduct itself in such a situation always depends on the court, means that the judge. And like Mr. Justice Manigrahi said, that every judge has his own temperament. But to my mind, a judge has to always be very, very conducive, cool, composed in court. He should not lose his temper. And when we say this, that he should not lose his temper, he should not lose his digital or virtual temper also. So in that way, we must put the lawyer who is not behaving properly while addressing virtually, we put him on alert. We must put him on alert by saying that after 1 minute you will be switched off. Before switching off, we must give him a notice that you will be switched off in 1 minute if you don't argue your point pointedly, or if you continue to behave irrationally in the court, you are not arguing properly, then one warning is always required. Because if we abruptly switch off, then probably that audio alterum patrum will pitch in.
Another solution what I have found, if the lawyers are errant and they are behaving in a very irrational way, arguing something irrationally, I say please come to the court, physical court. So that is the only thing I can come to the physical way. I give some time. After 3 days, 4 days, 5 days or whatever, you just come the next day, I will hear you. That's the only thing you can do.
Yes, please.
No, what we are discussing here, what are the difficulty we faced. 1 year back, last 25 March, excited holy vacation, we were there in Kenya for a delegation, the former Chief Justice of India and the present Chief Justice of India. We have witnessed there is rarely a physical court. Completely virtual and paperless court, and effectively having this thing from lower court to Supreme Court. That time, some online media wrote the judges went to 5,000 plus kilometers to learn from an African country for the virtual courts and paperless court. But really what happened there, it is that's why in many Commonwealth jurisdictions, we are having this kind of things. But we are not ready to adapt and learn that part from that. In that delegation, along with me, Dr. Vikram Singh Arya was also there.
Question for you.
Yeah.
What have you heard, just learned from Kenya experience about this discussion we had made about the errand lawyers and these things? What do you have learned from there?
What is that?
What have you learned from Kenyan experience about the tackling the errand lawyers there?
No, I'm saying, we have to think in a broader sense. But first we have to decide whether we have to entertain our clients and in the court in that line. We have to continue with the physical thing, and in a what is that, for sake of this thing, we have to have a virtual hearing or a hybrid hearing. Yes.
How many cases does a Kenyan judge have?
No, that is different. That is different. But how many judges numbers we have and their litigation also. We have to compare that one. We can't say that country is also following our many property law. Our law they are following still. That's why there are board, they told usually in the online that's system will create to them for how many cases they are to hear. That thing they will complete that.
Average, sir, how many cases they
Average, I don't remember that.
That is the main question.
Yes.
So without knowing that, we can't compare.
No, the problem is the mindset. I am saying the mindset. We are ready to do it or not. Not only the judges or the judiciary, the lawyers and the litigation. First we have to say, that's why this main deliberation we plan for that Judicial Academy and this has to come with the mindset of, it will come from a education perspective only. From there it has to come up.
Yes, Mr. Sivakumar is absolutely right in raising this issue and this question. But you see, we are here in this conference coming from across the country. What for? We are promoting this. It is not that we are discouraging virtual hearing and we are sitting here and discussing to control the virtual hearing. No, it is not. In fact, we are promoting and we are finding ways and means how to promote it, how to better it, how to do it in a qualitatively better manner. So that, why are we thinking that we should not violate the principles of natural justice? Otherwise, it is very easy for the court to say that we will not hear you. Why are we thinking to frame some SOP or do's and don'ts so that the work environment in virtual mode is also so robust, so properly framed that everybody would like to have it. Not only the judge, but the lawyers also. Slowly, they will, you see, there are 3 points. What Brother Patil said. There are 3 reasons why it is not coming so fast. First is that we are still in a transition phase. We are a vast country. We have a very heavy judge-litigant ratio because of the population pressure and because of the litigation pressure and because of the people at the remote sites, lawyers at the remote sites not being so much tech savvy, not because they don't want to, but they have their own financial constraints, they have their own, we may say, literacy constraints. It's a question of 3 points he has read, Mr. Patil has raised. Number 1 is habit. But habit comes to those who have this facility but yet they are not using it. It is not for those one who doesn't have this facility. Habit will come and set in slowly to all those who have this facility but they are not using it. Second is the confidence of using it. The fear of not knowing. As we say, the digital fear for a beginner is the fear of not knowing. One who doesn't know how to handle a computer or the screen. We always say that he has the fear of touching something in the computer and then losing the data and losing the link. And the third is the adaptability. One wants to do it, but he is not properly adapting himself for the new technology. But we are here to encourage and find a way out how to promote this digital and virtual system for all. I myself, I am not very well versed, but I am saying so many things because I know that this is the time we must adopt. Otherwise, we will be failing in, after some time, say 10, 15 years, 1 or 2 decades from here, if we don't convert into a virtual court, the burden of litigation, burden of cases will be so huge that it will be practically impossible for us to handle the physical files. So we are all, nobody should have any apprehension in their mind that we are discouraging virtual court. Not. Thank you.
Just, I have a question for my co-panelist with a thought. Errant lawyers can be controlled in various manner, contempt proceedings, because people are appearing from across jurisdictions, territorial jurisdictions. Should party in persons be allowed to appear? Because if somebody is sitting in some corner of South America and addressing arguments, it shouldn't be a case of hit and run. Because the court proceedings are live, it will demean the institution if they don't address correctly and don't follow the protocol. So therefore, in this digital process, should a party in person be allowed? Because you may not have any control except switching off. You might have done the damage by then.
I'm thinking of what Mr. Batul said. That could we not say that you should deposit 10,000 in advance as cost for your errant behavior, which is refundable at the end of the hearing?
Hello, respected Chair, I regret to interrupt. I would like to inform you we are nearing the end of the allotted time for this session. You may
One second.
proceed with the last.
Please.
I just wanted
Request the
to,
discussant to express his views.
no long statements.
Yeah.
I came here to just to listen to find it, because while we are trying to finalize the national litigation management policy, I have suggested to the government to have some chapter on these kind of issues, so that there's a cooperation between the E-committees and High Courts and Supreme Court and the Ministry of Law and Justice. But then we have all one problem, from perceptions. We have a lot of perceptions. So, and then we need to move to a different mental, preparedness. All these like a thorn in the flesh. I think we need to be able to remove those thorns one by one. I'm sure we move forward. There are, of course, important structural issues, but beyond structural issues, I said it's all a lot of perceptions are there. How do we therefore control our own mind as judges? How do we able to control the lawyers who speak on the other side? So when I began my journey with all this vote, now I have 3 or 4 iPads on my table and try to understand how I can regulate my own behavior on the screen. So the self-regulation is important. How do we inculcate it? Probably the judicial academies can do a lot of the job.
I request Mr. Lekhitan Basi to kindly express his views.
Honorable Chair and Justice of the Honorable Supreme Court of India, my lords, your leadership, it has indeed been a great pleasure and a great honor for me. And quite frankly, it was very difficult to intellectually keep up with my lords and your leaderships and with the esteemed Advocate General of Sikkim. But I will try my level best to list out my key takeaways from today's discussion here. So the voluminous amount of litigation has created a challenge of digitizing the old while transforming into a while transitioning into a virtual future. No doubt, as the esteemed panelists here have shared their wealth of experiences dealing with the transition from physical to digital, as the Honorable Justice Mishra, his Lordship, has talked about transitioning into and pioneering the concept of e-lok adalats, and the Honorable Justice Panigrai's observation that we have transitioned from a wooden bench to a computer screen. While the advantages are always going to be there, as observed by Justice, thank you. His Lordship has observed that the greatest challenge is to make the litigant feel comfortable. In this light, and I dare quote His Lordship, balance is paramount. Further, Justice Krishnamma, her leadership, has been advocating for the difficulties faced by various members of the bar when transitioning into a digital era. But she also highlighted that it was possible, observing that, that with the struggles that were faced, it was eventually overcome. Concurring view was that made by the learned Advocate General. I felt that the esteemed panel is in consensus about the fact that the development and transition into digital era of courts and legal proceedings is inevitable, but a check and balance is permanent at this point in time, since growth is occurring at the most nascent stage. This is ultimately a two-sided responsibility. The honorable courts to understand and implement, and for the advocates and the lawyers to adapt. Thank you.
Thank you to the chair, panelists, moderators, and discussion for such an insightful and engaging session. We will now take a short tea break of 15 minutes. Tea and refreshments are being served in the banquet hall at the end of this hall. I request all dignitaries and participants to kindly join us. We will resume the second session shortly. Thank you. Yes, we will resume at 4:45, 15 minutes of tea break. respect, and appreciation, may I request Learned Deputy Director, Sikkim Judicial Academy, to kindly offer khala to our respected dignitaries. We are deeply honored to have as the chair of the session Honorable Mr. Justice Ujjwal Bhuyan, Judge, Supreme Court of India. We are privileged to have as the co-chair Honorable Mr. Justice N. Koteshwar Singh, Judge, Supreme Court of India. Our esteemed panelist comprises of Honorable Mr. Justice Anil K. Narendran, Judge, High Court of Kerala. Honorable Mr. Justice Vinit Kumar Mathur, Judge, High Court of Rajasthan. Honorable Mr. Justice Sabyasachi Bhattacharya, Judge, High Court of Calcutta. We are also honored to have our moderators for this session, Honorable Mrs. Justice Josna Riwal Dua, Judge, High Court of Himachal Pradesh, and Dr. Salina K. Bashir, Dean, Hamdard Institute of Legal Studies and Research, Jamia Hamdard. The discussant for this session is Ms. Shruti Jain, Research Fellow, National Judicial Academy, Bhopal. Thank you, Madam, for the warm and gracious welcome. With this, I now humbly request our learned moderators to kindly begin the session.
Yeah, thank you. I'm Jyotsna Riwal Dua, serving as judge in High Court of Himachal Pradesh, and I'm the moderator for this session. The main theme for this session is judicial training with help of new technology, innovative methods and approaches. Before we commence our session with our honorable dignitaries, I would take the liberty of sharing a couple of experiences which I had last 2 weeks, involving some cases of the quasi-judicial authorities' orders. There was one case where the quasi-judicial authority had ordered issuance of warrant of arrest against a woman under a specific provision of act, whereas the sub-provision of that very act exempted the woman from being arrested. Then there was another case where the quasi-judicial authority had dismissed an application of the petitioner for grant of interim relief, holding therein that though the petitioner had a very sound case on the merits of the matter, but the application did not contain correct provision of law. Then there was this third case of quasi-judicial authority having dismissed an appeal of the petitioner. The petitioner had filed a revision petition. In the interregnum, that quasi-judicial authority got promoted as revisional authority. As revisional authority, the quasi-judicial authority decided that revision petition and affirmed his own order, saying that the order is very well reasoned, valid in accordance with law. Looking at the spate of these kind of cases, I asked the state law officers as to why don't they mull over having a training program with the Judicial Academy so that the legal knowledge of the quasi-judicial authority is enriched and they are in a better position to deal with the cases so that the justice is also administered in a better manner. Pat came their reply, that would be a very sensitive issue, the officers would not like it. So that kept me thinking. I was also wondering that we are also hesitant in adopting the new technology, new methods, and that's why this digital divide is still there, because we refuse to come out from our comfort zone. That said, let us commence our session. Our chair for this session, may I request Honorable Justice Ujjwal Bhuyan, Judge Honorable Supreme Court, to have the opening remarks.
Thank you. And good evening, everybody. I don't think we need to go there and address the audience. I think we'll do from here only. So we have a very distinguished panel here. My brother, Justice Koteshwari, is here. Distinguished judges from different high courts are here. And we have the one discussant and one moderator. Yeah. So we look forward to this. The caption of the session itself indicates what should be the model of training, interactive methodology. We have been, one way or the other, we have been associated with different judicial academies. The model applied mostly is the lecture model. I myself, I go to many places, deliver a lecture. At the end of the, or just 10-15 minutes, we try to squeeze in some time and we take some questions. I don't know whether the participants go back with any knowledge or not. The one who delivers the lecture, he benefits the most, because for the delivering the lecture, he has to do a lot of research. But whether the participants carry back with them the message or what the speaker would like to convey, I am not very sure. So, of course, the lecture model has definitely, it has its advantages, but over a period of time, we have seen that it suffers from various inadequacies. To cover these inadequacies, we have different kinds of methodologies in judicial training. For example, we have this interactive methodology. We have the mock trial and simulated hearing methodology. We have the case study method, role play and perspective taking method, structured small group discussions. These are different alternatives. Peer review of judgments, for example. They can be. These are different alternatives. But there are challenges in each of these training modules as well. As we move on with the panel discussion, certainly we'll discuss about the merits, demerits of the alternative methodologies that we are conceptualizing. But before that, my brother has a short PowerPoint presentation which he would like to present for the benefit of all the participants.
Our co-chair, Honorable Mr. Justice N. Koteshwar Singh, Judge Honorable Supreme Court of India.
Yeah.
Khamrimo, Tashidelek, Namaskar, good evening to everybody present here. Brother Ujjwal is here, along with Brother Ujjwal, Brother Narendran, Brother Vineet, Brother Sabashachi, Sister Jyotsana, Moderator Salina, Discussion Shruti, Sister and Brother Judges, I understand directors of various judicial academies, students, lawyers, ladies and gentlemen. Well, his brother Ujjwal also mentioned we have been participating in judicial academies for long, but it is similar kind of pattern. Whether there have been changes or not, we don't know. But of course, many of the judicial academies have gone for very model, kind of innovative ideas. I just thought I will just give a brief, because I prepared, but because of the shortage of time, I understand it will not be possible to in detail, but I thought I'll just mention a few points which came in my mind when I was preparing for this topic of discussion. I mean, the core idea is design interactive methodology in judicial training. As brother mentioned also, the goal of judicial education must move from lecture, from hearing to seeing, to sensing, to doing, and finally to applying. Because judging itself is not theoretical. A judge does not merely know the law. A judge listens, observes, questions, manages, reasons, writes and decides. That was a very different, kind of very complex kind of activity a judge is always engaged in. Therefore, the judicial training must also train the ear, the eye, the mind, the conscience, and the habit of decision making. Well, coming to the next, What is the urgency of this? We all know the kind of pressure we are in. Now we all know the third phase is already kicked in, and technology we are using in huge kind of proportion. But the problem is that technology without capacity creates hesitation, because see, are we all trained properly in use of the technology? Because we get stuck. Sometimes we try to fiddle with, अरे देखो भाई क्या हो रहा है भाई BC काम नहीं कर रहा है, ये CD software काम नहीं कर रहा है. Liquid text had a problem. Liquid text is given to the judges of the Supreme Court. I don't know how many Supreme Court judges use it. I tried to use it, I had a problem. There's so many issues. So capacity, that also must be matched with the technology which is given use to us. This is something which we have to deal in our judicial training. Not only Supreme Court, but the High Court judges, but also district judges. Therefore, we must see how we manage the e-filing. We must be equally competent. VC recordings, VC functioning, electronic records. We are the one who was the master of records. How do we do this? There are issues which I think the Judicial Academy has to look into it. But the problem is not the lecture itself. The problem is the lecture monopoly. That's what we want to say. Because, I mean, now Judicial Academy, wherever even we go, we give lecture and come back. I don't know how much it is really beneficial. It has, of course, the lecture has its own advantages. But then good teaching involves various other aspects which lecture does not provide only. And of course, judges learn through relevance, experience, and problems. We are not school students. All judges, lawyers, we have, middle age, advanced age. How do we do? We don't. The kind of learning process we have is very different. Andragogy, that's the experienced professional. We learn best when the learning helps real work. Our problems we face in the court, how we deal with it, I think, that's where we need to give up some focus. Prior courtroom experience, judges both asset and a habit to examine, because we are all the judges have vast experience in various ways. How do we interact? How do we use it? Best practices in different courts, they are something which we must utilize. And of course, interactive session, I don't want to go in detail. Yes. So, ideally, the program should be designed only when the desired change in the practice is clear. What do we want? For example, training on bail. Then how do we deal, what kind of challenges we face, what kind of problems we face in dealing with arguments, submissions, reason order writing, because we've seen that in most of these, sometimes bail orders are very, very, very summarily, they are decided. How do we deal with all these issues? Then not merely training on AI, because we have seen that many times the lawyers are so dependent on ChatGPT or something like that. They start giving. So we have to be also careful. How do we deal with these kind of issues? Are they giving the correct citations, verify citations, protect confidentiality, preserve judicial reasoning? These are some of the issues. So when we go back from our training, are we different from what we were when we came to the Judicial Academy or training session? This is something, so that therefore, not only with the kind of topics or syllabus we are going to discuss, but how we behave, how we deal with issues, challenges, is something which I think Judicial Academies have to. Simulation is another great, I'm sure there will be deliberation also, the simulations. This is one of the examples how we deal with simulations, begin with a dispute, not with the syllabus. That's how, because we always deal with problems only in life. And judges, we are dealing only from day 1 to day 2, 10:30 to 4, we are dealing with problem only. So we have to start with problems, how we start dealing with problems, how see problems, how problems are created, how problems are solved, how problems are resolved. So we must be, our focal point, our universe revolves around problems. How we solve it, how do we proceed it, this is something which judicial academies have to work out. I am trying to cut short because of short of time. Case studies again, which is used very extensively, used various, even in fact, in our LLB course also, we started with case studies. A very fantastic way of learning things. Facts of the case, what was decided, they show, then you correlate with actual decisions, not theoretical teaching principles of law, but what actually had been decided by the courts. Very important. And of course, comparative Commonwealth cases also, how different jurisdictions are trying to deal with issues. And now as we are coming one, the world is coming one, use of technology, AI, we are integrated, more and more integrated. Therefore, we must learn from other jurisdictions also. This is something which we can think of. And the diversity of jurisdiction becomes a learning resource also. Case studies, yes. I'll skip this, this is be a part of the case studies. Yes, next is role play, something which we hesitate to do because we are all adults. We don't like to sit like a students play around. But this is something, I think, which requires to be, I think, practiced. This is how we try to understand. The role play methodology is because every day we are dealing with human situations, angry parties. In a court we see, especially when it comes to family disputes, wife and husband shouting at each other. Even in the court, they can't control. We deal with these cases. Traumatized witnesses, inexperienced lawyers. How do you deal with that? Do you shout it down? You don't know law? No, you can't do that. All lawyers, they come from different universities, different colleges, some official colleges also. They got this degree. The Bar Council of India has given them, they have a right to practice. But you know the standard. How do you treat all this? These are all the problems also. And someday you find it petitioner in person. It creates such a big problem for the courts also. He doesn't know how to draft. He doesn't know how to address the court. What's all these things? These are issues, these are real problems. Cross-examination, how abusive, cross-examination, insulting, humiliating, how do we do this? Victims of sexual offenses, persons with disabilities, children's. These are all issues which we deal with every day. How do we deal with this? This is another aspect I think the Judicial Academy has to, because role play, that's how we try to understand what kind of situation a person, a litigant, a witness undergoes. Digital tool. These are, I think this is going to be, I'll skip this, how we decide, how do we use the digital tools for training, polls, like breakout rooms, create, they are where we, a very important thing about these digital tools, just to give an example of, a poll is useful when it reveals disagreement. A breakout room is useful when it creates peer reasoning. A shared document is useful when it records evolving understanding. An AI tool is useful when it helps generate practice, material, questions, scenarios, etc. So I'll skip this, or I'm sure it will be discussed also. And a very important thing, of course, which we miss out is before, during, after model, which many of the academies do not do it. The advantage of it is that if we give a proposal or some situation, short case law, whatever, so the participant come reading it, then actually it is being discussed during the session. Then after the session, we have a discussion, what is that we learned? This is something which we must inculcate, because otherwise it will be just people coming, standing here, listening, going back, without anything being absorbed. Now, these are something which we must inculcate in our training sessions. I mentioned about Commonwealth experiences we must take advantage of. So ultimately, the measure what changes and not only what was conducted is very important, because normally we see how many how many lectures, series were organized on how many topics, how many learned, eminent lecturers had come. These are something which we have to look into it. Capacity building must include whole justice chain, because what is happened in most of the judicial academies, we are only focused with judges. But judicial system, justice delivery system is not only judges. It depends on the lawyers. It depends on this staff, courtroom staff. It depends on the litigants. So that is a kind of imbalance. We are only training ourselves only, but we are not imparting the training which is required for proper conduct in the court of the lawyers. We have no control, obviously, the Bar Council looks after it, but there must be some ways we must include the lawyers in this judicial training also. This is my feeling. Otherwise, only we are the trained ones dealing with untrained people. Staff also so important, how much they help in the record management, how they deal with the clients, how they deal with the litigants. Perhaps the other one, before they even could enter the courtroom, they'll be dealing with this bench clerk or some attendant or something like that. The kind of impression it is created, how do they react? How do they react? How do they relate? How do they respond? It's very important. That leads to that also very big component of the trust and confidence which you always talk about. The strength of judiciary lies in that confidence and trust of the people on the system. But that is an area which is normally neglected, but that is an area where we have the most deficiency. Judges are wonderful, wonderful people, but then are there similar situations with those who are in the support system? So these are very important areas I think we have to look into. Well, I'll skip some of these. These will be usual. Barriers are real, but design can dismantle them. We are under tremendous pressure. Of course, how many judges will be attending judicial academies or training sessions? Time pressure is there. And hierarchy also. Especially, is a greater problem when serving judges address serving judges from the district judiciary. The problem is because the district judiciary, they don't want to say anything. Either it will be shown either if the person asks too much questions, they'll kind of, this judge is very, very, some judge may have that feeling. So they say better not to ask any question. Keep quiet. To keep mum is the best, because you don't know what kind of reaction this honorable judge from the High Court, when he sees the kind of questions being asked. So I think in judicial academy, we should have retired judges mostly. So that barrier, the fear barrier. See, we have very, very rigid kind of hierarchy in our judicial system. So nobody wants to take the risk. Baba, Choro is not to us. Yeah? So these are the fear factor, the hierarchy is something. And the resource inequality, of course, it depends from academy to academy. We have wonderful academies, Delhi High Court. We have wonderful Bangalore, Calcutta. They all boast of very, very good academies. But all academies perhaps are not equipped equally. So these are resource inequalities and other issues. Yes, trainer readiness is another area. How trained are the trainers? TOT, we keep saying TOT is very important. How we are trained to train others is something because it's very important, because the audience, the judges, learned judges of this are very, very, very sensitive also. Well, I want to skip this also. There are so many things to talk about AI. So this is basically from content coverage to capability building. That's, I think, the focus should be not much on giving too much of information in our heads of the honorable judges, where they have so many things to read. How much information want to put in Judicial Academy? Already so overburdened with this case. So how to deal with behavioral pressure? These are all areas which I think Judicial Academies must also emphasize upon. Concluding, dynamic learning, integrated training, better justice, active education, embed learning. So thank you very much for your kind attention. There were so many things. I'm sure the wonderful discussions are there. They will, I think, throw more lights on some of the areas. Thank you very much for giving me this time, brother.
Thank you,
I have
Honorable
taken
Chair.
more time
Thank you,
than-
Honorable Co-Chair. So may I first ask the question from Honorable Justice Narendran, our panelist, as to why should we leave the lecture-based pedagogy? After all, we are accustomed to it. We are comfortable with it. It is risk-free, even though we can forget the lecture, 60-70% of the lecture within next 2 hours.
Before my brother speaks, I'd just like to make it clear that anyone from the audience
Yes.
can intervene.
All questions are
All
welcome.
questions are open.
See, Kerala Judicial Academy is a place where we moved from lecture-based teaching even in 2018-19. Because I started going Judicial Academy as a resource person in the just before COVID pandemic. Initially, it was for district judges, mainly on motor accident claims, because a large number of appeals are there. When 100 awards are passed, 100 appeals will be there before the High Court. It was at that point of time this training session for the district judges started. And on Saturday will be identified all the district judges dealing with that jurisdiction will be there in the Judicial Academy. After the first training session, by the next time it was a COVID pandemic, so we shifted to this virtual mode. So normally 4 sessions will be there. First 3 sessions will be basically teaching with a lesser number of questions. And the 4th session is a rapid fire session. I will be there along with the directors of the Judicial Academy. 75 to 80% I will answer. Insofar as other questions are concerned, that will be supported by the directors. And each and every participant will ask at least a single question. And that started in 2019. 18 it started, then 2019 onwards it is going on like that. And another aspect is also there, because there was a mediation drive for the mediation for the nation 1.0. At that point of time, we planned a training session, which is in the form of a regional conference. 3 regional conferences were held, where the master trainers were there, all the referral judges, including the secretary of the District Legal Service Authority, who the nodal officer was there. All the board members of the board were on the dais, because we were interacting with the judicial officers. All the judicial officers were forced to ask at least one question in the interactive session. Training session went smoothly, and after completing these 3 regional conferences, we revised our handbook on mediation procedure, and it was published. And in the first session, first 1.0 drive, the total number of cases referred in Kerala, which is a small state with a limited infrastructure, is around 26,000, out of which 8,500 cases were settled. And now the second drive is also going on. There now all the judicial officers are working as a single team. Now about 86,000 cases were referred, out of which 14,000 cases were.
I just want to comment. See, Kerala, as I can understand, wonderful works. If the Kerala Judicial Academy, anybody who is trained in that, master trainer, he can be invited in any other judicial academy.
Even
And show that this is how our training takes place. Because see, every region has a peculiar, the kind of traditions of training program. Guwahati High Court, we all know, brother, we have a tradition mode which is going on for a very long time, So if we can learn, there is nothing wrong about it, because every judicial academy has their own system, their own tradition going on, But if you can infuse
last month there was a conference in
yes.
the National Judicial
I
Academy.
have just into the exchange of TOTs with other, we can learn a lot of things. Because see, frankly saying, Judicial Academy in Bhopal is good, but when we go back, we don't really implement.
Sir, we sit behind the corners. We find the
Last
corners.
month there was a conference of Board of Governors in the National Judicial Academy. I participated and I exchanged, because I have given to the resource person a detailed note on the training session we are
concerned
doing.
Director of the Judicial Academy must have received 50% of it, what you said.
Yes.
When he goes back home, he'll transmit only 10% of it. That's what I'm saying. If you go directly to a particular Judicial Academy, you'll be able to transmit at least 60, 70, 80% of it. That's why I was suggesting just
Right. In fact, sir,
yeah.
if I just may put in, normally from lecture it's one-way transmission of information.
Yeah.
If we are also, if the trainee is also
Mic's off.
involved,
Mic.
if the trainee is also get to involve and he is also asked, instead of, because in Judicial Academy we fill up the form, we assess the trainers. But if we are also assessed,
So
and
therefore, what I say,
So
there
if-
should be more collaboration,
collaboration
collaborative efforts amongst the different judicial academies.
there would be active involvement.
More exchange programs.
Yes.
There will be more exchange. And one more thing I would like to butt in here, the new methodologies are good, very good. I agree with that. But I also feel that the lecture method, with all its shortcomings, inadequacies, it is still relevant. It is still relevant because we only invite domain experts, and we have lot to learn from the domain expert. In fact, while delivering lectures, I don't know about others, I can say for myself, I have learned so many things. I don't know whether the participants have learned or not. So lecture method is good. We can think of modulating the lecture method by having more interaction putting in there, instead of completely discarding the lecture method. For example, mediation. We can invite great mediators to share with their experiences, and then we can have group discussions, case study method, all this, everything put up.
Sir, we actually had a session where the trainer was the computer tech-savvy expert, but probably he was PhD degree holders and we were nursery students. So whatever was being said, everything went off the tangent. So probably the trainer also has to understand the profile of the trainees, and their capabilities.
Even there is an evaluation of the trainers also, because after the training session is over, all the participants will be asked to submit their response. That will be kept confidential. And then we will get an idea about whether he is because he is able to convey the entire thing to the participants.
Right. So what should be the, Brother Mathur, what should be the scope and feasibility of
What I
simulations?
think, yes, a very good evening to the Honorable Chair, the Co-Chair and the Honorable Judges and the students. The theme basically is moving beyond lecture-based pedagogy, and to my understanding, what we have to teach is that too much of lecture is becoming nowadays very overbearing. So it is now an era started where we are from knowing to doing to measuring. So it is basically we feed them something and then involve them. And after getting their feedback, and once they go to the actual courtrooms, then we assess them. So this is the basically training to participate. In the training itself, we should participate after giving lectures. We must hold courtrooms like we call it simulations and all. We'll come to the next topics. And as the flipped presentation is there, As in England, there are, I have prepared a PPT, sir, but it will take time, I know. So that is why I'm just skipping all those things. So in England, they have done the homework very nicely, and the flipped courtrooms, flipped classrooms have becoming a very good success. What they are doing is they are just giving the topics a day prior, and then they hold the meetings on the next day. Then all those judicial officers are called, and they exchange their notes. So that is actually the actual scenario which is being taught. That is the actual problems that we will come to the second and the third point, because second point is the methodology and the third point is the tools. So for employing that methodology, the tools which are utilized by all judicial academies are actually the themes which we are required to pass on to these young judicial officers. And then ultimately, in the peer learning, the exchange takes place, and after that, the fifth point which we enter into is the measuring the training impact, which will come later. Whatever we have taught, whatever we have instructed, whatever we have imparted is required to be resultantly seen by us. So it is only a moving shift from that basic lecture series to doing and then assessing it. So the tools which are being utilized for those methodologies which we are going to adopt is the actual today's need. And in that perhaps there are different ideas, topics which are being exchanged, and we are implementing them successfully.
Next question to Brother Bhattacharya. But before...
Can I say something? I just wanted to share a good practice which we have started at Judicial Academy Assam, where we see the few of the orders of the judicial officers are picked up. And then in the training program, it's a cluster training program where we share those orders with masking their names so that the judicial officer cannot be identified. And we ask the judicial officers to find fault with the orders. And we have found that this has impacted the training, and then it has benefited the judicial officers. Thank you.
Brother Bhattacharya, before I ask that question, I'll just quote one example. I was very young and naive lawyer, about 3-4 months old in the profession, and I was arguing a case before Honorable Justice Kamlesh Sharma, the first lady judge of our High Court. And I was trying to demonstrate before her that width of the path is this much, and it's very narrow. Therefore, the construction on the side of it needs to be demolished. I was not making any headway. The judge was more concerned with the legal wrangles. I was very weak on that. Now, next day, I was very young. I took the liberty. I came armed with a ruler. And I said, sir, ma'am, this is the width of the, this is the length of the ruler. Double the length of the ruler is the width of the road. Road is very, very narrow. Please order for its demolition. Judge was stunned, looked at me for a minute, burst out laughing, and I came out from the court smiling. This prompt helped me. Of course, we can't utilize it in every case, but now the role of simulation. So how do you think that the simulations, the role-playing exercises, the mock trials, the case clinics, that helps in the judicial training?
Taking a cue, first of all, I wish all of you a very good evening. Justice Singh, Justice Bhuya, all brother and sister judges here. Now, taking a cue from your first question and relating it to this, I'll be saying that before you could say pedagogy, the pedagogy in our lives have been replaced by andragogy, and our bright faces have become jaded ones. So, what I want to point out is one of the linking factors of pedagogy and andragogy. It's not so different, is interest and passion. So once you lose that, all theoretical discussions about how you should proceed about it gets lost. So I think there should be a core identification first. First is of what is a competency, deficiency, and interest. These things we have to take a poll if we want from the judges, and we can then assess make some models. because two important factors are there in andragogy. The first is that it is need and experience based. So it's need based, unlike pedagogy, and also experience based. And need and experience are very interactive things. Your whatever you need, that creates your experience, the world of your experience, and vice versa. And also it's self-directed and self-paced. So to take that into account, and your simulation comes in there. But what I mean to say is, instead of a lecture-based model, we can identify those core areas of competency, deficiency, and all those things. And we can create, say, broad-based models. Suppose models will be on there will be generic models, like, say, gender justice will be one model, ADR, IPR, and we should not forget that apart from the things which are in vogue at present, commercial law, ADR, and all these things, these are very good. But we should not forget the core things also, the civil, the theories, first principles of civil law and criminal law, those should be incorporated there. And how does simulation come in there? Because whenever you prepare the modules, that should be an integrated, various formats should be integrated in that. So as Justice Bhuya and Justice Singh were pointing out, lecture has its own value. So if you circulate, suppose it may be 6 into 2-month modules. You give a module, first module, if it's a 1-year based program, the first module contains one of the generic broad domains. You give 2 months. It will be self-paced, self-directed, and that module will include not only lecture-based videos, but also simulation within that, built within that, within the architecture. And also apart from that, there can be polling and other tools involved in that itself. So after 2 months, when the lecture happens, the lecture is not a lecture, it's an interactive session. It can be, half of it can be by virtual, half of it can be physical. It can be intra-domain, 6 different groups studying different domains, intra-domain, and also some of it will be inter-domain. And when that happens, that interactive session will include various modules. I mean, you can put in simulation there, polling there, role-playing there, and if it's virtual, you can have breakout rooms. So it has to be an integrated thing. So simulation has its role, lecture has its role, but you have to integrate all of them.
Right.
And after that, there should be, I'll just take one more minute, and there should be an assessment. How should the assessment happen? Pre and post ACR for the district judges. And also it can be a self-assessment as well as a peer-based assessment. So all these things have to be integrated, not one at the expense of the other.
Right.
So this is my idea of how simulation should
Right.
come.
In fact, the traditional based lecture system, the traditional methods of training, they focus more on the legal principles, the case studies, they do provide the foundational framework, but at times when a judge sits in the court, then these methods may not equip him with the practical challenges he meets in the court.
Correct.
So therefore also these new methods assume importance. For example, I had a case where the order was passed by an energy regulator. Order was running into pages and never-ending pages. And it was very complex order. I had to spend good amount of time just to understand the arithmetic of that order in order to comprehend what the order was. So I was thinking to myself, if I had some sort of training into this subject matter, probably some time would have been saved. So
That's where the integrated modules help.
That's correct. So yes.
Hi. Hello, thank you for the opportunity. I just wanted to say just one thing. When we go to Judicial Academy in Bhopal, we are about 30 to 40 judges most of the times, and we do meet up everybody, build a lot of relationships. We know our friends and our colleagues from different courts. But one thing I feel is, sometimes it could be a one weekend session for one entire high court itself. Because within our own high courts, it will help a lot between rosters, how people with experience on that roster can help in disposal. Look at the pendency figures, how to do the, quick disposals. It need not be judges from different courts. Sometimes we could even try one full High Court coming to the Bhopal Academy and having a frank discussion.
Do that in Delhi.
In Delhi, it's not possible.
The resource person can go to Delhi High Court.
This is basically for those young judges. This entire exercise
Within
is
the
being
High Court,
done
we
for
don't
the
get time to
Judicial
interact
Academy.
with each other.
Sir,
There are ways of looking at it. National Judicial Academy, Bhopal, is not meant, this is my way of looking at it, is not meant for teaching High Court judges the basics in law. It is an academy where you exchange your views and you sharpen your intellect. So the deliberations in the National Judicial Academy per se would have to be at a different level, not on the basics. So one should not go to the National Judicial Academy that I will learn the basics of IPR or I will learn the basics of competition law.
So on a lighter note, we can have also LOL sessions, laugh out loud sessions.
Yeah.
So where we discuss the immediate superiors. So district judges discuss the Supreme Court, the High Court judges. We discuss the Supreme Court judges.
And also in Judicial Academy, we have in 2-day session, if 2 days or 1.5 session, there are so many subjects. We end up, we discuss, without discussing, somebody speaks and the whole session is gone. We don't then, by the time the lunch time comes, then another session. So is there a really meaningful, therefore I would suggest, I don't know how, there should be only one topic for the whole day or for 2 days.
See,
no? Then have different views,
yes.
as brother says, various high courts, what is their view on that, what is the take on that, Rather than have, 3-4 sessions on topics, we end up doing nothing actually.
The initial session in the Judicial Academy, I'm not saying about the High Court judges, I'm saying about speaking about the judicial officers. See, we are not born judges. We get selected, I'm speaking about judicial officers, we get selected through a competitive examination. We come from different backgrounds. We carry many things we learn at home. So when you become a judge, you have to start on a new slate. So in the Judicial Academy, the first thing one is required to do is to unlearn yourself. All that, your baggage that you have carried from your family, from your relatives, from your neighborhood talks, because you are now on a different job. You are not judging. In Indian context, not only in everywhere, judging is very, very sacred. So you have to unlearn all those things and start learning what is expected from a judge. This is very important. The first and foremost when a person enters into the judicial service, because from there only, because we nowadays sitting in the Supreme Court, we come across orders from various courts, sometimes even from the high courts, which perhaps we should not be coming across such orders. This, I believe, that something is there lacking, or he comes with a preconceived mind when he becomes a judge. And then he puts into action what he carries, what is there at the back of his mind. So it is essential for an academy to absorb everybody, the persons who become judges, judicial officers, so that they unlearn themselves and then start learning from a new slate. This is very important.
I fully agree with brother, because I think that our focus may be on the base of our judicial system. Those who are new inductees, because they are the one who need to learn. Not so much about district judge level. You can't teach a district judge level anything new except those new areas of law, evolving laws, on cyber crime and all these new evolving laws. That's okay, fine. That we can discuss. But then basic fundamentals of judgeship, it has to be inculcated at that base level where they must be given the best. As they are better trained, they will evolve better. I think, but somehow we are not, I think.
The psychological evaluation is good. That is it is the way in which this can be identified at the very beginning itself.
Yes. I think the base, training at the very base of our system is so important. All this what discussed, in fact, my presentation was not meant for judges, honorable judges of the High Court. It is not meant for that. I mean, these are something.
Sorry. A lawyer who gets who is directly elevated in the High Court, he may not have practiced in all fields of law. Whereas a judge who is coming from service, he has some vast experience already, and he also knows about the court management. So the lawyer who is directly elevated, he has some sort of drawback over there. But there is no as such training program for the directly elevated judge, though Judicial Academy runs that program for a day or two for the newly elevated judges, but not such which can equate him at par with that of the service.
Yes, yes.
So
That also what
there is
sister
some
also is
problem.
correct. No, because, see, what we say, we mix, we see in the Judicial Academy judges from the service and bar.
Yes.
With different kind of ideas between the background. So, for example, generally, service judges have a problem in dealing with writ jurisdiction, for example.
And sir, we have faced
How to deal
problem
with
in the
that? So,
court
there can
administration.
be proper, how to deal with writ jurisdiction for the judges coming from the service. I mean, that you don't have to teach these judges from the bar who have done so much. Then, but the bar, those coming from the bar, they need to be talked about some areas where they have never touched. Some are very expert in, cyber crime, or some expert in commercial law, or some other, IP, but then may not be equally, conversion in criminal law, something like that. So where there can be a deficiency of knowledge, perhaps that can be made up. So we should try out, when we request the directors, concerned directors of the academy, that please send those judges who would like to have more, intake in these areas of, rather than, because what has happened, I mean, sorry to say, high courts, many of the high courts do like that. किसने नहीं किया जुडिशियल अकेडमी, चलो उनको भेज दो. कितने बार है, इसको मत भेजो. कहाँ से कौन डिस्ट्रैक्ट है? I mean, there should be a proper assessment of those people who are going to be sent to judicial academy. Because otherwise, it makes no sense. You come and go.
That's why probably the competency, deficiency, and interest factors should be factored in.
Factored. That should be done by the judicial academy must brief our concerned committee. Judicial, who will decide.
Should be the correct people should be brought for the
these are judges who perhaps require, they have volunteered, they would like to know more about this, say, intellectual property right, or they want to know about writ jurisdiction. So then they can classify and accordingly send according to the requirement. This requires a lot of, fine tuning and, small level.
Is also, and ask the judges, or assessment should also be there from the Chief Justice or whatever. So the deficient people will come, and those having interest will be coming.
High court should
Instead of
also, yes.
What happens, we send the people who are sitting in commercial court for commercial court training.
Yes.
But it should be the other way around, I think.
Yes, and High Court also, perhaps in collaboration with Judicial Academy, concerned that find out, yes, he's the one, she's the one who has done well in this, that he or she can be a TOT, within that system. And I think these are something which we have to do, some kind of assessment at the High Court level. Our committee who looks after this training.
In Kerala, what we are doing, when an office, there is a training session, we will invite willingness. Then thereafter, the director of the Judicial Academy, who is a district judge, will evaluate it, and then a proper person will be sent for training.
I think yes, it will save.
So coming back to the subject, next question to Brother Mathu. We are probably world's largest and busiest judiciary. We are always under extreme pressure to render timely, consistent, and well-reasoned judgments. So how we as adult learners meet these expectations with aid of the technology and new methods?
Yes, right. We are under pressure from all corners because the mounting pressures are creating difficulties as far as the higher judiciary and lower judiciary is concerned. That is why the tools like polling, breakout rooms, and AI-assisted learning is being brought into the action. And we are training our judges in the Judicial Academy on the basis of simulations, problem-based learnings, and role play. These are the methodologies which we are employing in order to train them to deal with the situations as fast as possible. That is the first thing. The second thing is, my take is that all these tools are required to be utilized for the processing of the material, not for the final decision. because all these tools and gadgets and methodologies are basically to understand better, to equip us better, and then ultimately the delivery should be from our own side. We should not utilize these tools for the purpose of writing judgments, because lately we have come to know that all these gadgets are being used, the problem is being fed and the judgment is being written. We will be creating a great disservice to our institution. And mounting pressures, yes, all these tools are being utilized for the purpose of getting ourselves equipped to deal with the situations, to assimilate the collection of data, to know, because different problems have been, we are training our judges in different forms, so that you have rightly said that once a lawyer is made to sit on the chair in the High Court, sometimes on the first or second day, we sometimes don't get to know whether it is on the left side. All throughout
Correct.
we have been doing that, this is from petitioner side, this is from respondent
It
side.
is always the different
But-
view from the other side.
But in the very first week of the sitting, we don't get to hack of it, that oh, it was from petitioner side. It takes time to absorb. It takes time to get into the system. Sometimes very first day or second day or in first week we write some judgments. After 3 years we know, when we read that judgment, what have I written? So it takes time. So to overcome that problem, all these things have been kept in mind, and we are training our judges to equip themselves, and when they really adorn the chair, they are faced with all kinds of situations which they can probably handle nicely than a person like us who was sitting in the court in the first day, and if was given a independent roster, we were not knowing the bouncers were coming from this side and that side. So to train our judges to deal with that situation, we have to utilize these tools like polling, the breakout rooms, and AI learnings.
Right, right. Brother Narendran, we talk about digital tools, as Brother Mathur just said, the polling, breakout rules, AI, e-learning, video conferencing, and all that. How is it possible to integrate the new methods with the old methods? Can we complement the two systems, old and
so
new?
far as the use of AI, that can be there for searching a decision, or even for...
No, can we complement the two systems? Can we take two systems together?
That's
Yes.
a challenge.
Yes.
It has to be also. Even we have to do it, because we live in a world today, 50% are, say, illiterate digital. Digitally illiterate. You can't expect them to function. Therefore, we have to combine. That's what this hybrid mode has to be always there.
And very importantly, we have to...
So far as reasoning in a judgment is concerned, that should be by the judge.
Yes.
No,
reasoning, yes,
of course, that is there.
And because for searching certain decisions and even for formulating the points, certain judges are using it.
I just was thinking, Sister Jyotsna was mentioning about, see, we have all the honorable judges in the high courts. They have law clerks. Appoint law clerks who are adept in technology. I mean, this is something we have to, because see, we don't have time to verify the citations given, the hallucinations and all this, all the wrong.
Red
So they can
lines.
do this, checking, all this,
Right.
do these basic checks.
Right.
We must employ law clerks who are adept, very conservative, with the new technology, because that will help us a lot in our decision-making process.
Sir, I
So we
was
organize ourselves.
so sorry. I was just informed that we have to curtail the session period. So, sir, one question from the audience demand. Sir, one question from the audience at the demand of audience. Sir, normally sir, normally a judge tries his level best. He renders a judgment, good or bad. It is challenged in the higher court. There are always two views possible. At times, even more than two views are possible. A judgment is set aside. Fair enough, that is also part of judicial learning. But at times, while dissecting the judgment, some comments may come indirectly against the author of the judgment also. So what is your take?
See,
Should he not because he can also get demoralized in his process
it
of
happens.
further learning.
It happens. It happens. I won't name anybody. It's a real case. He was a special judge in dealing with this terrorist-related cases. He convicted the accused at the end of the trial. The judgment suffered from several inadequacies. Had I been an appellate judge in the High Court, I would have also set aside that. The then Chief Justice, sitting on a bench, set aside that judgment. He is within his jurisdiction to do that. But while setting aside that, in the meanwhile, that special judge had already become a High Court judge. So he became his colleague. While setting aside that judgment, some very adverse, caustic remarks were made. And it's recorded, got it recorded. So the learned judge, now High Court judge, he filed an SLP before the Supreme Court against this remarks made. And a bench of Justice Bopanna and Justice Sudhanshu Dhulia set aside those remarks. So this happens. Problem is this, we can get rid of this. Once the judgment is over, once I deliver a judgment, I should no longer think what happened to that judgment. I have delivered the judgment keeping my thinking, what I have understood, what I thought should be the correct at that point of time. At that point of time itself, there can be a second view. In a subsequent stage, appellate stage, you take a different view. So one should not stick on to what that I had delivered this judgment, oh, he has set aside this. This will not only cause us a lot of difficulties in adapting, it's totally unwarranted, uncalled for. And the system is as such, if you have such caustic remarks made, there are ways and means of getting rid of those. One should not carry this beyond a particular point. This is all part of judicial life.
Thank you so much, sir. Thank you, Honorable Chair. Thank you, Honorable Co-Chair. Thank you, all my panelists. Thank you, Clea. Thank you, Sikkim, and congratulations for being declared as first paperless judiciary. Keep learning. Keep evolving, because that's how society learns. Now, my co-moderator, and over to my discussant. My co-moderator. Co-moderator.
Okay. I think some really excellent points were made. I'm not going to repeat them. It would come across as a second copy of the original. I'll just make a few points that I thought were in my mind that we should consider when we are talking about technology and integrating it into judicial education. We are operating on the presumption that the participant group is a homogeneous group, and we are far from that reality. Actually, if borrowing from a categorization I've seen of learners made by Mark Prensky, we can safely categorize our participant judicial judges into three categories. And the coinage I would like to use is digital natives, digital immigrants, and digital aliens. Digital aliens are the people from the old way. They are familiar and they are comfortable in the way they are. They are inimical to the ways of technology. In fact, some are indifferent, and some are, in fact, apprehensive of technology. That is one category of participants that we need to deal with. The second category are immigrants, those who have moved from the old ways, transitioning into the new ways. They love the old ways, that's the comfortable way of life. Often they lean back, they often have a laptop as well as a notepad, both. And they are comfortable with both ways, but they are moving slowly into that section. And we are now progressively, and this is true for the newer batches coming before the state judicial academies, the new entrants, they are completely born into the way of life that is now digital. So they are, now for them that's a different challenge, because now they inherit a legacy that we have given them. So to be familiar with the legacy that we offer, that is the old ways, and transitioning and getting used to dealing with that as well. A very interesting thing about natives is they are prone to reading less. So how do you handle these three categories in training? So you need to target a bunch of judges who don't read, while you have a bunch of judges who like pen and paper. So targeting all three categories in the same training is a challenge going forward. So that is one area I thought we should consider when we're talking about integrating technology into our trainings in judicial academies. That's the first thing. And the second question I had was, how far can we integrate technology? Can we go as far as having entirely AI-based trainings? Can we eliminate the physical presence of judges in a certain place while we're doing trainings? Is that possible? Is that feasible? Is that right? Is the question that I ask. And I would say my answer to that it's not, I think, advisable. Peer-to-peer exchange is something that ultimately serves a purpose. And we've seen with COVID times, having a virtual training doesn't exactly serve the purposes of learning, especially for practical, reality-based trainings like judicial education. So a harmonization of both forms in a form of blended learning is, I think, the right way to go forward. And my last point that I would like to make at the end of it all is, this is a signal for the future, and that is, I would pose a question, that we talk about the competencies of a judge, and in judicial academies, that is the major aspect that we are focusing. It's not enough to have knowledge of law. It's also the qualities, attitudes, and skills that go into judging, dealing with cases, dealing with your roster. Now, I would pose a question, are judges now have an additional duty of technical competence? Are they required to be technologically competent is a question going forward. And I pose that, I don't leave it answer. I think it's a question for all judges of all different categories, both the immigrants, the natives, and the aliens, to consider whether, going forward, technology is something that you should know as a judge and should be conversant with. I'll leave an example to highlight the reason why technology and the competence of a judge in dealing with technology is something that we need to consider. Now, there is a case in UK, and this would be reality for a judge who handles that case, where a person was sexually assaulted in virtual reality. Now, this judge has to first understand what is virtual reality, what is the parameters and the dimensions of the transaction that happened on virtual reality, and reassess and recalibrate the accepted, established notions of sexual assault. So you may have a sexual assault on virtual reality, which may have all the psychological and emotional trauma without the physical manifestations. So for a judge to deal with technology, he needs to deal with AI. He needs to deal with these kinds of emerging ways. So maybe somewhere going forward, technological competence is something that judges would need to have. With that, I would just conclude.
I think we will have to.
That's all I have now.
Yeah, thank you. Thank you so much. Thank you so much.
Thank you to the Honorable Chair, Co-Chair, distinguished panelists, moderators, and discussion for a truly insightful and enriching session. Before we conclude for the day, I take this opportunity to inform the August gathering that Honorable Chief Minister of Sikkim, Sri Prem Singh Tamang, will be graciously hosting the state dinner at Mayfair Hotel, Gangtok this evening. All guests are kindly requested to arrive at the venue by 7 p.m. With this, we come to the end of today's conference. Thank you all for your gracious presence and participation. Wishing you all a very pleasant evening. May I kindly request all dignitaries to please join us for a group photograph.
Oh, where group here? Here.